second instance of contact is on 3rd of September. And my lord, you issued orders at 10 a.m. There was no appearance. You issued further orders at 3 p.m. There was no appearance. My lord, those are 3 instances. My lord, on 5th of September, equally, you issued orders that he appears on 5th of September at 10 a.m. He did not appear. A 5th instance of contempt in court. You directed, you were gracious enough to direct that he appears at 3 p.m. My lord, he did not appear. Cumulatively, these are 6. Today morning, it's the 6th instance that the Inspector General of Police, the first respondent, has refused to comply with this court orders. My lord, that is the context within which we find ourselves as petitioners in this matter. Will this court give another chance for the Inspector General to appear before it? My lord, if that is given, then it will be a further violation of the Constitution, particularly Article 10 of the Constitution. The Inspector General has a duty, which duty is abrogated. Your directions were that he himself, not his deputy, appear before you. Having given that context, my lord, I want to invite President Nelson Harvey to submission.
Lord, it was not my expectation that I will stand here today, having stood in this very court about 5 years ago before your brother Justice Luka Kimaru on a matter similar to this. Having appeared before this court again 7 years before your very same brother Justice Luka Kimaru on a similar matter. I'm talking about the matter of Miguna and the matter of Willie Kimani. My lord, the conduct of the first respondent must be deprecated by the court. And in the strongest terms possible. My lord, the very criminal justice system that the first respondent stands for is incapable of performance but for reliance upon court orders. It will therefore be turning logic over its head to allow the National Police Service, which comes to this court day after day for summons, to compel attendance, for warrants to enable search, to fail and attend court to give an explanation as to the whereabouts of 3 Kenyans. Lord, it is for that reason that at the tail end of this discourse, we will ask the court to do 2 fundamental things. 1, to convict the holder of the office of Inspector General of National Police for contempt of court. And 2, holder of that office to the highest permissible penal consequence. And if 6 months is the highest permissible penal consequence, it must be cumulative for the 5 orders hitherto disobeyed. And fundamentally, my lord, this is not a personal office. It is a public office. So that as you convict and sentence, my lord ought to make a declaration of violation of the Constitution. My lord, allow me just to refer to 3 authorities and in very brief. My lord, the first case is the case of Dr. Fred Matiang'i, Dr. Fred Matiang'i versus Miguna. Sorry, it's Miguna versus Dr. Fred Matiang'i. Petition number 51 of 2018. It's reported as 2018 UK now. Lord, your brother, Justice Odinga, as he then was a judge of the High Court, was met with a case where the then Cabinet Secretary for Interior had refused, one, to appear in court and explain the whereabouts of Dr. Miguna. And secondly, it failed to produce Miguna in court. Lord, at paragraph 11 of the decision made by the judge, your brother judge, he underscored a fundamental concept. He said, in this case, it is clear that the respondents are the ones in charge of security in this country. They are in effect in charge of execution of warrants of arrest. They have clearly shown that they have no respect for the rule of law and will not comply with the orders of this court. Lord, in reliance upon that limitation, Justice Odinga proceeded to declare the contemptuous there as having violated Article 10 of the Constitution. Rightfully so, because we asked for that declaration in order that Fred Matiang'i, the then Director of Criminal Investigation, George Kinoti, and all the respondents should not hold public office. We want Gilbert Masengeli not to hold public office, because this is not his personal property. Lord, the second authority I want to refer your lordship to is miscellaneous criminal application number 57 of 2018. It's reported as 2018 UK law. But this is a serious enterprise. My classmate Charles is a studious practitioner of law. He asked this. And we argued this case with him. They have been started.
Let me finish, because now we cannot stop anyway. And then if you need time to look at the authorities,
that's okay. Thank you so much. Look, the second is decision that I'm referring to, that is the case miscellaneous criminal application number 57 of 2018, reported as 2018 EKLR. The responsibility, similar to the one bestowed upon you, fell on the shoulder of your brother, Justice Luka Kimaru, a judge of the High Court as he then was. And my Lord, significant to this enterprise is what the judge said about the right to be heard. And this is what he said. If the second and third respondents chose not to appear before court and give their extenuating circumstances, the court will have fulfilled its legal obligation of giving the second and third respondents a chance and a hearing before the final verdict. Not simply put, for the ease of understanding of policing, because these concepts may appear too complex for them. The right to be heard is given. If it is not taken and exercised, the court has exhausted it.
May I interrupt to record to appear for the respondent in their personal capacity, not in their official capacities.
No, my Lord, this drama should not be accompanied by Mr. Danson Omari has made a habit. Whenever policemen kill innocent Kenyans, he comes to court to interrupt a serious discourse. So listen to him, but he's represented by capable individuals with the same office.
Yes, ma'am.
You see, what we need to do is we need to come on board because the restaurants are already represented. We need to come through Mr. Mutembei. Mr. Mutembei can introduce you.
My Lord, if I present my case before
Let-
the former law society of
Because
Kenya,
we are in the proceedings. Would you kindly sit down and we allow Mr. Ari to finish? I will hear you after that.
my Lord, serious allegations have been made that the police cannot understand anything.
Kindly sit down, Mr. Ari.
Very well. Much better.
Well, before my learned friend rudely interrupted me and paused at that point where he said, the right to be heard, if given, must be exercised. If it's not exercised, the court has performed its duty. And then your brother judge concluded thus, as top police officers, the second and third respondents are required to be at the forefront in respecting summons issued to them to appear before the court. The entire criminal justice system will collapse if bonded witnesses fail to appear before the court to give evidence just because they are of the view that they can choose to or not to present themselves before the court. Hook, line, and sinker to Gilbert Masegeli. Lord, my successor twice, Madam President Faith Ujabo, has illustrated the triviality of the events Masegeli was attending to. Let me illuminate them further. He was even attending a concert. In Kenya, a show, a concert, is treated as a matter of national importance. We are ashamed. I'm indeed ashamed to be a Kenyan. 3 Kenyans cannot be accounted for. You are attending a concert and you're telling us that that is a matter of national importance? Lord, let me conclude with a decision by the Court of Appeal in civil application number 1 of 2017, reported as ELR 20. Civil application number 1 of 2017, 2018 EKLR, Miguna versus Dr. Fred Matiang'i versus Miguna Miguna and others. Well, this was an appeal from the decision of Lukatamaru. Lord, when we appeared before the Court of Appeal, we cited the case of Jones versus Bill Clinton. And the Court of Appeal adopted our submissions word for word. And my Lord, in the case of Bill Clinton, if I may paraphrase, this is what Chief Judge Susan Goldberg had held. In that regard, there simply is no escaping the fact that the president deliberately violated this court's discovery orders and thereby undermined the integrity of the judicial system. Sanctions must be imposed, not only to redress the president's misconduct, but to deter others who might themselves consider emulating the President of the United States by engaging in misconduct that undermines the integrity of the judicial system.
Give my court assistant copies of the position.
Yes, I'll give this. My Lord, say for the Gen Zs who were not there when these matters were happening in the United States of America, we all know that this is the decision that disgraced President Bill Clinton. It never recovered. My Lord, I've handed over the question. My Lord, Gilbert Masengeli must never recover. Let him be a destitute, a disgrace, a misfit of the law, as he has chosen that to be his ultimate path. My Lord, the Court of Appeal concluded its analysis of that matter with the following strong words. When courts issue orders, they do not do so as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cathedra are compulsive, peremptory, and expressly binding. It is not for any party, be he high or low, weak or mighty, and quite regardless of his status of standing in society, to decide whether or not to obey, to choose which to obey and which to ignore, or negotiate the manner of his compliance. Lord, what my learned colleague has exposed us to is exactly what the Court of Appeal has said should not be done. To negotiate the manner of compliance. Lord, in conclusion, I beseech the court to come to the finding that the first respondent, and in particular, Gilbert Masengeli, has been given the right to be heard. He has refused to exercise the right to be heard. Gilbert Masengeli, as an individual holding public office, must of necessity bear personal responsibility. So that, my Lord, as we ask you to impose the heaviest penal consequence of 6 months times 5, my Lord, we also ask you, in the event that you will be minded to give a penalty of a fine, the fine be borne personally by Mr. Gilbert Masengeli, to be deducted from his salary, as was the case for Mr. Noti when Justice Odinga was here. My Lord, we will also ask that we have a time date when the registrar of this court will come and confirm compliance with both penalties. For the penal one, that he has surrendered himself to committee maximum prison, and on the fine that it has been deducted from his salary. Lord, as I sit down, I'm still silent. They had a big role in putting this guy into office. I'm ashamed, profoundly ashamed, because this is the only cabinet in the history of Kenya that has a majority of lawyers. The cabinet secretary in charge of interior is a lawyer, a professor of law.
Would you please confirm yourself?
Thank you, my lord. That underscores my disappointment. I beseech you to convict Gilbert Mutembei.
My lord, yes, I'll beseech you for just a few minutes, my lord.
Mr. Abiy has taken a lot of time.
Yes, he has, in his traditional way and format. My lord, I would,
What he has taken.
yes, I would actually not repeat what Mr. Harvey or either of the other advocates on behalf of the petitioner have said before you. My lord, I've had the privilege of appearing in several of these cases. The first case we appeared in was the case of Herman. My lord, I've always believed to date that it is the actions that the Law Society and other players took to move to court for an habeas application
So the petition of that was supposed to be submitted.
with Kimani, the disappearance of Willie Kimani. And my lord, it is the action that was taken, and my lord, even in that case, orders were issued to the Director of Criminal Investigations and to the IG, and it is those actions that were issued there that were critical in the subsequent conviction that was undertaken. Now that just points out how important these proceedings are. And my lord, you issued two orders. One for the attendance of the first respondent, and second for the release of the second, third, and fourth petitions. My lord, both orders have not been complied with. My lord, the other case that I have been involved in was an advocate who was abducted with his client, Professor Nando. We moved to court. The court issued similar orders. He was released, but his client was never released. And I'm not up to date. Professor Nandwa knows and acknowledges that he owes his life to the orders that were given by this honorable court. And to date, he has never opened up at exactly what happened when they picked him with his client. In fact, if you want to make him cry, just ask him what happened. The third instance, my lord, is of a client of mine who we appeared in court. He had been taken by police at Saddleton. And the court also issued similar orders, summoning the IG to appear in court. Subsequent to that, he was released. He's been brave enough to tell me exactly what happened.
But my Lord, the wife tells me that for him to sleep at night with the lights off is a big problem. And so, my Lord, I wanted to say this to underscore just how important the orders that you give are to the justice system, because in certain cases, it saves a life. In other cases, unfortunately, it does not save those lives. But it enables the family and friends to have an idea as to exactly how they died and to pursue, perhaps if they choose to, reparations for their death. So, my Lord, perhaps this may not be something that the court is aware of, although I would want to believe that it is aware of the significance of the orders that you have given. It is not just the question of compliance with court orders. It is an attempt to save a life. And where the Law Society or any petitioner appears before court in an attempt to save a life, my Lord, I want to submit to you that there is no higher calling. And so it doesn't surprise me when President Harvey is feeling the way he is feeling, because it is a calling on all of us. And it doesn't matter on which side you appear, because today it could be somebody else, the following day it could be me. And that's the reason why, my Lord, I want to beseech you, because the Constitution beseeches you to do that. To enforce it, to give it life, because our Constitution will be meaningless if it cannot protect the right to life. So, my Lord, whenever someone sits somewhere and designs a plot to abduct Kenyans, they must know unequivocally that the court will frown upon that behavior, and that the court will take the strongest possible legal sanctions to deprecate that kind of behavior. So, my Lord, we beseech you, that on the face of what we are facing today, there is clear grounds for handing out the highest sanctions as have been suggested to you by President Harvey. And my Lord, by doing that, you will be answering a call that is contained in our Constitution that guarantees the right to life. And so, my Lord, as you retire to prepare your ruling, I just ask that you have that in mind, that the actions that have been taken by other courts have actually saved lives, and we are asking you to give the sanctions that we are asking for in a bid to save lives.
On record for the petitioner. I would like to bring the court to your attention that these dates, my Lord, as requested by the respondent, they we made a request that the first respondent will be available before this honorable court today, which the court graciously granted. It is my submission that particulars are not made in vain. For the court orders were issued a while back, and it is upon this court to enforce them. My lord, assuming it was Parliament or the executive, ordering for the first respondent to show up for an explanation, my lord, he will be there on the first day. He's there for quite sad, but the respondent is literally a mockery of this court, my lord, and not only this court, but the judiciary as a whole. That is all.
Lord, with your kind permission, Lord, on behalf of the second petitioner, I'd like to make short points, specifically on behalf of the second petitioner, and I associate with what Learned Counsel has said on behalf of the petitioners together. My Lord, we appeared before you last week twice, and as my learned friend, as Rebecca among us, reminded the court, the last order the court issued for the physical appearance of the IG was made at the request of the counsel representing the IG, having consulted his client. The IG acting in the office, in the public office of the Inspector General of Police, for the purposes of this order, includes anyone in the acting capacity in that office. The orders you issued apply to Mr. Mutembei. My Lord, this court must act in the manner that it has been invited to find the Inspector General in contempt and to punish the holder of that office. My Lord, the second petitioner up to date has not been found. We are here because of a matter of very grave concern. The petitioners having laid before you more than plausible material indicating that the abduction or arrest or disappearance of the officials is at the behest of the respondents or the officers acting under their command. Must be produced before court. That initial order remains uncomplied with. My Lord, as we have stated before you, the order of habeas corpus is a last resort order to indicate to the state that constitutional authority is undertaken only within and in accordance with the Constitution. And the powers of national security can only be exercised by the agencies established and set out under Article 239 of the Constitution. And no person can create a paramilitary or anyone with a command to undertake the security services set out, which are subject to the principles under Article 238 of the Constitution. Even in the very unlikely event that the persons missing are not held by the agencies who are the respondents in this matter, they still owe an explanation to this court. That is the reason why this court did not suggest, did not request, but ordered that the IG, the person acting in the office of the IG, appear physically before this court and give this court an explanation. My Lord, we have placed before you the very clear provisions of the Constitution and authorities to support this position. My learned senior Harvey has this morning restated the authorities which we placed before you and the respondents last week. My Lord, we have this court sitting on similar circumstances has found persons of comparable authority or higher, as was the case of Mr. Matiang'i, in contempt and punished them. And my Lord, this court has been very gracious to the respondents. This court has been very ready to hear explanations, to hear requests, and in many instances be very agreeable to the respondents. But the power of this court must now be exercised, and we invite you to find the acting or the Inspector General in contempt, to punish the holder of that office, by a penal sanction of imprisonment and a pecuniary sanction or fine, but more importantly to find that a holder of the office that does not respect the principles set out under Article 238 of the Constitution, who does not regard the command of this Constitution that national security functions must be exercised with recognition, or under the Constitution and the recognition that they are only exercised within an accountable civil and democratic government, should not be fit to hold office. My Lord, that is the only thing that this court can tell the victims and the people of this country. That we take the right to life seriously.